Good morning, Taylor Gang. I see y'all in here bright and early. How you doing, Miss Kim? Miss Percy? So we're getting ready to watch the YNW Melly trial hearing. Um, they're going to be hearing some motions, but y'all, do y'all know that Broward County put a search warrant out on the female attorney's phone, and Apple reached out to her and let her know that they requested it and they have her records. I am so interested and invested in this hearing right now, okay? I am so interested and invested because, baby, what? How y'all just, hey, good morning, Pam. How y'all just up and take that woman's phone records? How is that legal? I didn't tell her. Like, what if y'all have anything that's confidential in there? Let's, client attorney privilege. Like, how do you differentiate that? Because I know that they I'm about to show it to y'all too. I know that they they had the little thing out there where they felt like um she was helping aid him or something. Like, I'm gonna show it to y'all because I was looking. I went through yesterday and was looking. Um, Yesterday I was looking at motions and stuff that was filed yesterday just to kind of get an idea. And child, when I say messy, 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 messy. Yes, y'all. But they literally have they literally requested that lady's record from Apple, and Apple told her. And they want to know, like, is she still under investigation? Is she not? What did you come up with? Like, what was you looking at? Everything. Like, they want to know. So I don't know why it's not coming up. Am I spelling his name wrong or something? Let me go back now. Let me make sure I spell his name. Yeah, I'm spelling his name wrong. That's why, y'all. Hold on. Yeah, I'm spelling the name wrong. Let me show y'all this. Okay, y'all ready? I'm finna show it to y'all. Let me make sure I got this tab pretty close so we can quickly switch back over to the. I'm gonna try to do it real quick, y'all. Let me make sure that I'm not. Okay, can y'all see that? Good morning, Bama girl. Okay, y'all, let me show y'all this. Girl, says after the trial was over, it became known that Assistant State Attorney Kristen Bradley and the State Attorney Office withheld information that would bear the veracity and integrity of the lead detective Moretti, right? Due to the withholding of potential Brady violation and subsequent action, that she was disqualified from the case. All right. And then although the defense also requested these charges be dismissed for for misconduct, prosecutorial misconduct, basically that was denied, right? They had other motions requesting the same thing, and it also was denied. October 4th is when they decided to press charges for him tampering with a witness. And they were put on the defense was put on notice that the state would be using the facts of the tampering case to show consciousness of guilt in the first degree murder charge. So we know that that's going to be coming in on this second case, right? Right. So on December the 18th, the attorney for the defendant, Mr. Demings, Raven Liberty, was informed by Apple, literally this year, a couple weeks ago, she was informed by Apple that on December 13, 2023, her Apple account information had been provided to the Broward County Sheriff's Office pursuant to a search warrant. To the extent of what was provided and what was revealed is yet unknown to the defense. The basis of this search warrant of Miss Liberty's Apple account is also unknown. Without knowing the extent of the information seized by the Broward Sheriff's Counsel Office, y'all know what I'm trying to say. Mr. Demons do not know what confidential communications and trial strategy between the various defense counsels were revealed. Okay, in order for the defendant and the counsel to make proper decisions, a conflict and potential waiver of saying the following questions need to be answered: is she still under investigation, or is it over with? If the investigation of Miss Liberty has been terminated, is there potential for it to be revived once again at a later date? Y'all, they didn't went and got that lady information and done had it for about a year. Okay, they didn't went and got it and had it for about a year. Ain't told nobody what they doing. Ain't said that she's under investigation. Ain't pressed no charges. Nothing. Okay. And so they're saying like, okay, you know, they have to have a hearing based on the law. They got some case law cited there, and they want to know what, if any, confidential information between the defense counsels is currently in possession of law enforcement in the state. The people want to know. The people want to know, y'all. What y'all thoughts on it? Let me know what y'all thinking, because I'm thinking they did wrong and they went and tried to see if that lady was helping that boy or trying to help that boy break out of jail, and they might be looking for any type of communications in which because y'all know they also alleged that she was trying to give him some pictures or something of his girlfriend, some nude pictures of the girlfriend. What y'all think? What y'all think? Let me know in the chat right now, because that right there alone is crazy. It's crazy. That's crazy. Crazy. I know it's early, y'all. I'm still getting myself together. I looked up. It's a snow day here, y'all. And so my kids are basically upstairs, so we might not be able to do our regular streaming today. I want us to get through this motion hearing, but we may have to postpone our stuff until tomorrow, because my kids are here and y'all know the baby here, so we may not be able to do our full stream. But I need to know what y'all think about this. Because, baby, the judge should sanction them and tell them if they found something there they can't use, because that's ridiculous. Shay, okay? Because they shouldn't be able to use it. They should not. They should not. Baby, and how y'all want to seize that lady stuff and didn't tell them, didn't press no charges, didn't do nothing. They said they want to know what's going on. They said they need to know, what did you go get? Why you got it? Is it over with? Are you talking about picking it back up later? What's going on? When they got a search warrant for that lady stuff? Shay, he been in jail for like 5 years. He been in jail since 2019. The M happened at the end of 18. He got picked up. He got charged in, I want to say, February of 19. He been locked up ever since. I don't understand how that's legal and what loophole they found to make it legal. Exactly. What was the probable cause, baby? Because we need to see it. Because here's my thing. Y'all didn't already charged him with all these things. But y'all haven't had no hearing or anything. So, I mean, I can understand if it's still a part of an investigation, but child, what's going on? Shay, baby, they been trying and everything. That boy in there raising HE double hockey sticks. Mickey, I hope that Mickey, that's you, right? Big Angie, not the little one. I hope the audio is better too. Not even gonna lie. Not even gonna lie. I hope the audio better too. Melly and her raising up HE hockey sisters is what they allege. That's what they say in their. That's what they saying in their show. So he got a whole nother lawsuit. Hey, with corporates out there asking them to let him go, and they responded back to him like, baby, you up in here, you using other people pens, you trying to communicate with people through false mail, you threatening the guards, you flooding the toilets, baby. They say Melly in there going ham. I think this is the trial judge Shay. These should be the motions that they actually got early last year, which was crazy because they actually filed another motion too that we just didn't look at, where they were asking basically like to continue to do another continuance, and it's like y'all done had a damn year to look at this. What you mean? Good morning, Jen. Okay, because what? So yeah, we really just waiting on them to start. But I want to know why that lady was under investigation, because what's going on? Man, Cam, I wish that it was just not as much snow, because everybody and their mama here today in my house. Everybody and their mama. I need everybody and their mama to go. Everybody and their mama need to go home. Need to go to school. They need to go somewhere. I'm so tired of them people. They've been here for 2 weeks. They need to go back to school. Good morning, Miss Georgette. Georgette, I think my package coming this week, girl. I'm gonna do a unpacking I'm gonna do an unpacking video so that I can promote your stuff on my TikTok too. I need to go get me a PO box set up for real, because people be wanting to send me stuff, but I don't have a PO box. So I need to get a PO box. I need to get a PO box. It's snowing in Philly now. Yes, y'all, we got 12 inches here too. Hey D. Mm-hmm. Mm-hmm. The whole city shut down. Girl, yeah. It's practically shut down here too. We've been shut down for 2 days. The grocery stores look like apocalypse. Look like we in the middle of apocalypse, because baby, they was bare bones. Bare bones, nothing. Nada. Not a thing. But I hope people stay off the roads today so that they can plow them and treat them. That's one thing I like about living in St. Louis, is that our road crew is super familiar with these types of conditions, and has our state properly funds them to treat our roads. Whereas when you go like further south, I think they put like sand down or something like. And I'm thinking, like, I understand sand can be a treatment, but baby, up here, we need a little bit more than that. We need the liquid chemical mix that's gonna melt the ice. We need it all. No snow here, but it's 21 and likely to snow later this week. We don't know how to drive on icy roads. See, that's what I'm saying, Georgia. We ain't got time for people like y'all down there. We ain't got time. We are supposed to get it by the end of the week. We're only getting flurries today. Not here in Texas. That sand don't help. That's what I'm trying to tell you. But I can't. That's the only thing I fear about having to move down south. Like, if it's snow, we know how to drive in snow. We get it. Maybe you go to another state, they don't have no clue. They don't have the slightest. City be shut down for 3 days because of 1 inch of snow. I can't do it. I'm trying to get to the market now with a cast on. Oh, Vedas, sit down, girl. Get on DoorDash or Instacart. Hey, Miss Annette. Let me refresh this to make sure that we ain't missed nothing. Cause okay, I'm just making sure. Yeah, our city said that they will only be using salt. Jen, what city you in again? Here in Kentucky, they canceled school today for 1 to 2 inches. Oh, no, Megan, no, ma'am. No, ma'am. Our kids would be going to school up here. They really would. But here's the thing about St. Louis too, like, we a hit and miss. So they could predict like 4 or 5 inches of snow, and they will call school, and we don't get nothing. It'd be a little dust. So it'd be hard to tell like what's gonna happen. But baby, they predicted what if they predicted 6 to 9 inches, and we got 12. So it's like we either gonna get it all, we ain't gonna get none. We have you, Annette. What you scared of, baby? What you talking about? Memphis? Oh yeah, okay, yeah. Y'all look special down there too. Y'all look special down there too, Jen. Y'all look special down there in Memphis. Midwest writers, come on, Tamara. Come through. Hey, CMT. Come through, Tamara, because yes, but we know what to do. But the crazy thing is, living in St. Louis, like, I would be terrified to move to like Colorado or Nebraska, where they get like snow. I would be terrified. Like, no, man. Oh, so while I got y'all in here, I don't know if y'all seen it or not, but I did do a 1-minute recap on DA Jackie Johnson. It's Jackie Johnson. I did a 1-minute recap on Jackie Johnson. Do y'all want me to play it for y'all real quick? I could play it for y'all real quick if y'all want to see it. Because, yeah. I'm going to do, I got a 1-minute recap on Jackie Johnson. I'm going to play it for y'all real quick. If you don't know why the DA down in Georgia, Jackie Johnson, is getting ready to go to court, let me give you a 1-minute. If you don't know why the DA down in Georgia, Jackie Johnson, is getting ready to go to court, let me give you a 1-minute recap. Now, back in 2020, Jackie Johnson was the DA down there in Glenn County. And on her clock, Ahmaud Arbery was unalive. Ahmaud was gunned down by 3 men chasing him in a pickup truck. Greg and Travis Michael and William Bryant was sentenced to life in prison, as they should, because this father-son neighbor duo was wrong. Greg was driving, Travis had the thumper, and William was recording. Plot twist, Greg is a retired investigator and used to work for the DA, Jackie Johnson. The indictment alleges that Jackie went and asked somebody else to take over the case because she was a conflict of interest. But even though she still did that, they say she was still out here trying to help Greg and his son. But the long arm of the law got her and said, baby, you didn't violate your oath of office, baby. That's a felony. And we're going to slap you with a misdemeanor for interfering with a police investigation. Jury selection is supposed to start on January 24th, and this lady is being represented by Brian Steele and Keith Adams, y'all. Now, that was our boys on the YSL trial, but I ain't gonna hold you. I'm going against them this time. And you know I'm gonna be streaming the trial, so make sure you follow me on YouTube. Okay, that was my 1 minute recap on Jackie Johnson. So, y'all, since we finished the YNW Melly trial, I think that it would be good for us to watch their trials before we get the hoods. So we're actually going to switch over to rewatching the trial for Greg and Travis McMichaels and William Bryan. Okay, y'all. So if you're part of Telegang, that's what we get ready to do next. If you have seen it before, if you haven't seen it before, you can still come watch it with us. If you're not subscribed to my channel, make sure you subscribe today. Okay, because that's what we do over here. That's what we do over here. We trial watch. Good morning. Hey, Angel. Yes, girl, stay watching from the bushes. Oh, Annette, you on a lake? Child. The next try to watch is Travis Rudolph. Oh, here we go. We got action, y'all.
March 6th. But I can also call Mr. Angel Montes on page. Actually, the second week of March, I believe the judges are at Judicial College. I don't know for sure, but for now, let's not do March 13th, but you have March 6th. Also, if there's any change, I'm sure you'll get a memo. Next case, call Mr. Angel Montes on page 7 on the topic. Yes. Judge, so I just asked him on his new law. He's currently being held on this case as well as the new law. The state is not willing to discuss in terms of the student. I would ask if you're only willing to put him on standard or he doesn't have any history of violent crimes. He's not in thefts right now. Do you have a copy of, did you file a motion? Okay, do you have a copy of his sheet, false affidavit, anything that the court can invite itself? I can provide those to Your Honor if the state can give a moment to review it. I just would be Your Honor over the case here and it was brought to me this morning without a possibility for me to review it, but I will provide Your Honor with the clear sheet and call that. Okay, so we'll put it on recall. Next.
Good morning, Your Honor.
Good morning.
I have on page 27 of your own docket, Amy Garman. Judge, we're set for set new dates. I know that Ms. Garman actually reached out to my office last week while I was out of town. And I believe she lives out of state. I did send her a waiver of appearance form, but haven't received a signature back. But if I can waive appearance for the purpose of today's hearing, Judge, I would ask for a February 6th calendar call.
Your Honor, actually, the case is going to be transferred before we set that engagement with the older case in Division FD. So, Your Honor, I'm going to present the clerk with a transfer order. And I believe there's a date for the newer case February 3rd, at 9 a.m. So there's already a date? Yeah, well, there's a date for the older case in that division. I was just there last Thursday. So we're going to transfer, and then this case is going to be set for that date?
Right.
Yes, Your Honor.
In front of that other information.
Correct. Okay, sounds good.
Thank you kindly, Your Honor. Thank you.
So we're setting it for what for that day?
I think it's up for a calendar call on the call with February 13th.
It's up to Your Honor. I guess. I mean, it's going to a different division, so
right, exactly.
I don't know what they have it set for.
And Your Honor, I can look into who is the RCC person in that courtroom, and I'll coordinate with them to make sure that. Okay.
Thank you.
Thank you, Judge. I think that's all I have for you today.
If you can, Your Honor, just give the state just a moment to provide my clerk with the transfer. Sure. Thank you. Okay.
Thank you.
Let me just advise the Public Defender's Office that case Jordan Weiss has sent a message to the court advising that they live out of the state. They cannot be here in person. She's not allowed to travel. So the Zoom link was provided to them.
Thank you, Your Honor, for giving us the information.
Your Honor, if the court is ready, I would like to call Brian Brown on page 11 of your docket. Mr. Brown, Your Honor.
What page did you say? 11?
Page 11, Your Honor. Mr. Brown completed an application for the public defender today. It appears as if there is a change of charge date is outstanding, and we are asking to reset it for tomorrow.
State any objection?
I just want to know the purpose of the reason.
It's change of charge.
I understand you changed your previously.
Yeah.
Okay. Just
Yeah,
for record, I know that,
Yeah.
I know we're all aware, but for the updated, no, Your Honor, no objection to that.
So we're resetting it for tomorrow.
Come back tomorrow morning.
Anybody else? Good morning.
Good morning, Brett. Happy to be good, sir.
Happy New Year.
Good morning, Judge Alexander Wiles in the state.
Judge, Mike's up.
Yeah, I was there too. I remember you. Move us around. Here, good luck. This is somebody else's card. I just tried something else to find in there. Yeah, those first six are the same. The last four is 86. That's how you can put these over. Leave a voicemail. Come on. Hey, David, to remain on bond. You want me to write it down?
The new statute that is in Veterans Court for this area. I will need a statute to state their opposed to objection. One of the Americans said, unfortunately, I can't accept the case. So we're actually going to ask for this to be reset for after 30 days. I spoke to this morning with $200. We've probably gotten the substance of some of the issues. I think this is time that I have opportunities to discuss with the state whether that's an important decision. So I was asking for a reset.
State any objection?
No objections to the reset, Judge.
What are we resetting it for? For status, calendar status?
So, I mean, today I know it's for set new dates. Obviously, we didn't have a date present. I'm fine with setting it for a status if you want, or a calendar, whatever the purpose is.
You want a status?
Yes.
So, you said 30 days. 30 days from today brings us to February 3rd. This division's being taken over by Judge Villalonga starting the 22nd. So I'll set it for that day.
22nd of January?
Yes.
No,
No. The division's being taken over January 22nd. the date that I'm setting it for is February 3rd. So that's gonna be before a different judge in a different courtroom.
We actually had a person who did their project.
Okay, what day would you prefer?
I can do any other day that week, I'm out of the office on that Monday.
Okay, any Tuesday, Tuesday the 4th,
Tuesday, fourth time.
so February the 4th at 9 o'clock.
Thank
Thank
you.
you,
Nice to
Judge.
see you.
Have a great day.
On this one.
Morning, Judge.
Good morning,
I have posted reminders on page 13 of your calendar. Happy New Year.
happy New Year.
Oh, my God, our end of the day.
What page?
13.
Yes,
We're here for a change of please. Before we get started, Mr. Ramirez, of course, is down to surrender. So my question is regarding this, I think, this resident surrender date in 2 weeks, so he can get himself healthy.
state,
Judge, I have no problem with that. We discussed that, he was going to 5 years, the ultimate sentence is 3 years Florida State prison, followed by 10 years probation.
well, first of all, if he's sick with the flu, he should not even be here. So I don't even know why we're not resetting everything. We're here spreading germs.
I just didn't want not to show Judge we were here for this week thing, so.
Okay. So reset it for 2 weeks.
Are you
Any
gonna be here in
specific
2
date?
weeks, Judge?
Huh?
Are you gonna be here in 2 weeks?
I'm gonna be here, the 24th is my last day,
That
so
day?
reset it for that day if you want. That's Tuesday.
Judge, I have a, Judge, can we do it on the 20th, the 21st, and the federal court?
The 20th is a holiday.
I can see if I can have someone stand in. I have a federal matter that morning. If it's okay with my client, I can have someone else stand in for me. We have a plea paperwork prepared and I'll leave it with the state, so.
Okay, so, we'll reset it for January 21st at 9 o'clock.
Okay, Judge.
Thank you.
Thank you. David Seltzer.
And by the way, Judge Villamonte is not coming to this courtroom. She's just taking the division. I'm not reading courtrooms.
Judge, it's okay. I don't want someone standing physically versus I'll be on Zoom that day.
That's
Just so I
fine.
can be present. Okay, thank you.
So let me get this straight, you're still gonna be doing criminal?
Yes,
Oh, all right, so that's,
I'll be taking
this
the
is in division.
FP division.
Mr. Rodrigo, body, Arijo.
What page?
Very good.
What page?
I don't know.
Wait till he leaves you.
29.
I got it right here, 29.
Oh, okay, we're here for
A motion for early termination of his probation.
do we
I
have,
think the motion is clear, but I don't know. if it's
see,
for- Yeah, because I don't think it was written for early termination. I know within the body of the motion, there's a request for that.
They didn't cut the stream on us. What's going on? Line crime? Are we in the wrong courthouse? Y'all in the wrong courtroom or something? What's going on, line crime? Let me go check Kathy's Twitter, y'all, to see if she's shared anything relevant. Nope, she only said that I guess we don't stand by friends because what's going on? I don't know. I wanted to know if they was gonna give homie an early termination of his probation. What's up? He does have a new judge. Cindy, they gotta have Rule 22 because their camera was set up, but it seemed, I mean, the way that it was presented to us, it said that it was a 2-day motion. I mean, 2 days of motion. So it felt like it was gonna be just them in court going through all of their motions. But that feed that we just saw was everybody going in there having their motions heard. So it's like, what's really tea? What's going on? And again, y'all, I'm just checking back with Kathy on Kathy's page to see what's going on. I haven't seen her post anything, so I'll give her a few minutes to let us know what's going on, but that's plain as tea. So again, Taylor Gang, Happy New Year. If I haven't talked to you before, or if I missed you, Merry Christmas. If I haven't talked to you since before then. So again, y'all, after we finish, okay, today's gonna be a short day. After we get done with these motions, I am getting off the stream because it's a snow day here. My kids are here, and child, I gotta be here with this baby. So we won't do a full day of streaming today. But remember, Jackie Johnson. What do I want? Is that her name? That's her name. Jackie Johnson's jury selection is coming up. I think it'll be beneficial to us to rewatch the murder of the guys who actually were convicted of unaliving him. So we are going to be switching over to that trial after this. We'll probably start tomorrow though. How are y'all up? How are y'all surviving up there in the snow? Well, see, let me tell you, I be prepared for things, okay? I prepare. That's my thing. I like to be ahead of the game, ahead of the curve. So I went and got groceries days before. We are stocked up. There is no need for anybody to leave the house at this point. Hey, Willie. There's absolutely no reason for anybody to leave the house at this point, okay? While I wish that those children went to school today, because I didn't see them for 2 weeks straight, they are still here. But today they will be. Apparently, people didn't wash their clothes, so they're gonna be washing some clothes today. Okay, and that's what's gonna happen. Well, I know. Yeah. Good morning, Mama T. I be trying to instill a little independence in the people, but child, it's like I got to be on their back. I need y'all should have had them clothes washed already before the end of 2024. So their little new year might not be good to them. It might not be good to them. All right, let me refresh and see if Kathy got us a PSA out here or something. All right, I just commented because, girl, we need to know what's going on. We need to know what's going on. We're doing the same here in Texas. Dallas-Fort Worth is cold. You know what, Sonya? I was thinking about applying to a school in Fort Worth, Texas A&M. I think it's in Fort Worth. I was going to apply to them to go to their law school. I actually changed my mind, but they was on the list this weekend. They was trying not to wash anybody out the family, so they wanted to wait. Cindy, child, they should have had them clothes washed. Them girls did not wash them clothes. Let's say Samaj. Oh, sorry, y'all. Somebody sent me an email. I got completely distracted. Completely distracted. I was thinking about Memphis too, but I was like, yeah, I don't want to go down there. We're just waiting on an update, y'all. Like, I would hate to end the stream and then have to restart it because the people decided that they were going to start the stream back up, but I'm trying to figure out what's going on. Mm-mm-mm. Just trying to see. Baby, that audio was terrible. No updates yet, y'all. No updates yet. All right, let me see if I can check over here. Where my girl Beta at? Because I know Beta didn't put a good post in here. All right, so while we wait, make sure that you go in and you like the video. While I scramble to find out what are. Okay, Kathy girl, we need an update. We need you to tell the people what's going on. Let's see, girl. No updates yet, y'all. Still waiting. Still waiting. All right, let's see what y'all talking about in the comments. Good morning, D Wood. Yeah, they don't know what happened either. Are there any local news stations in the courtroom? That's a good question. Let's do a little YouTube search. Let me duplicate this. Okay, so it is a strong possibility that they are postponing showing anybody's court case until they get to Melly's, is what I just kind of gathered. What you say? What you say, Jen? Hold on. Jen, what you say, Jen? I skipped over. What you say? Don't do Memphis, girl. Memphis is like the cousin of St. Louis. Okay, that's our little cousin. Or y'all the big cousin? Let's see. Okay. See, yeah, so yes, I think they waiting on what we could do is look at some of the motions. If y'all wanted to look at some of the motions, if somebody could be on Law and Crime Watch, I could go look. We can go look at some of the motions that they are supposed to go over. That's a good way for us to kill our time. Y'all good with it? Okay, Jen, I think y'all older than us by a couple years, but we bigger than y'all. So y'all like, we the big little cousins. But we, y'all in the club, we all fam. Yeah. Mm-hmm. 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 All right, so I guess y'all just gonna have to listen to me because yeah. I don't want us to miss anything. Or if I keep the sound on this one, it'll pop up. And so I could show y'all the documents. Whatever y'all want to do. We could do one or the other. But baby, these motions are over a year old. Like, oh. Let me see if I find one that's interesting. How about that? Yeah. They did have an interview, y'all, with one of the. Oh, I did see this. Yeah, he's still in timeout. I did see this one, y'all, which I thought was kind of funny. As long as the audio is on, I think whenever it comes back on, y'all, we'll be able to hear it. But I did see this one and I thought it was funny. So I'm gonna show it to y'all. Let me fix the feed so y'all can see the document. Oops. I thought this one was pretty hilarious. Okay, so this one is the order prohibiting the use of Zoom communication technology. All right, so on December 5th, the court conducted a calendar call on the case in Florida versus Jamel Demons. Since live in court proceedings resumed in 2021, following the pandemic, the court has used Zoom communications technology on a daily basis to allow attorneys and parties to appear remotely and also to allow the public to observe court proceedings remotely. This court has set up the Zoom communications technology in a manner that allows attorneys and parties and the public who join the Zoom meeting remotely to always see and hear everything that is said in the courtroom. However, the attorneys and parties and the public who are actually present in the court 4780 were not able to see or hear anything that is said on the Zoom meeting unless the court activates the audio and video equipment in the court 4780. This setup allows the undersigned to activate the Zoom audio.
Well, there are things we will ask, and we'll say we can't provide, we'll go through the motions of what we need to do, and we'll do what you need to do. But then a long time is gonna have to be spent with him as to what he wants to do, you know, and that's not a 2-minute discussion.
No, I agree. So you haven't discussed it with him or?
No.
Got it. Okay.
Because Raven is not even here today because she's been flying back from Montana since yesterday morning.
Oh, wow.
Baby, it looked like we was in the wrong courtroom. Okay, so now we know Raven not there because she flying back from somewhere. And this is the courtroom that they're in, and they are waiting to do the things. All right, so I got the audio on, and again, whenever the audio comes back, I will. Matter of fact, I can just read, and then if the audio jumps on, I'll just stop. So just listen to me, y'all. Okay. So basically, they have a Zoom in the courtroom. They've had it since the pandemic, and it's up there to allow for people to view the proceedings remotely, right? If audio is initiated for someone, it's done by somebody in the courtroom, is what I've gathered thus far, right? So on December 5th, at least 5 participants in the Zoom meeting broadcast inappropriate material, including multiple images of nudity and pornography. This court notes all of these participants were admitted to the Zoom after identifying themselves as an attorney party, public observer, or another legitimate participant. These images also included written messages in support of the defendant and written messages requesting to free the defendant. The court notes all legitimate participants in the Zoom meeting were exposed to the inappropriate material, including multiple images of nudity and pornography. The court was forced to halt all court proceedings, and subsequently the court was forced to end the Zoom meeting. This resulted in delaying the completion of the motion calendar and also delaying the continuation of jury selection in an unrelated first-degree murder trial. All right, this court is unable to conduct court proceedings also while monitoring all participants in the Zoom meeting to make sure inappropriate material is not being displayed. The court is unable to identify any person who joins the Zoom meeting and is unable to determine if any person who joins the Zoom meeting is a legitimate participant. This court refuses to allow the dignity of the judicial system and the decorum of courtroom 4780 to be negatively impacted by citizens who broadcast inappropriate material, including multiple images of nudity and pornography. As such, this court finds there is a good cause to prohibit the use of Zoom communication technology per the rule. It is therefore ordered and adjudged that the use of Zoom communication technology is prohibited and will be unavailable for use in any future hearing involving the defendant. So basically, y'all, they done banned Zoom communications in a trial because somebody got on the Zoom showing pornography, saying free Melly. Yes, they was in the Zoom meeting causing havoc, y'all. I thought that was a funny one that I read yesterday too. All right, let me see if I can find y'all another good one. Let me see if I can find y'all another good one. There's been quite a bit of depositions filed too recently. Oh, there was a motion to strike on because they basically, like I told y'all, they basically didn't want to have the hearing. They claimed that they received things late and they didn't have enough time to review it and go over it. So I'm curious if we're gonna hear that motion argued today as well. But there was a deposition that was introduced of one of the officers in the court who was on Melly watch. I thought that one was pretty interesting too. I didn't make it all the way through it because Danny Polo. I didn't make it all the way through it because it's 82 pages long. And so I didn't make it through, but no. Danny Polo was about the rap music. Hold on, this is the wrong one. Let me go to the other one. So I need to read Danny Polo too. Thanks. Okay, it was the deposition of Raymond Beltran. Where's the audio? No audio, y'all. Y'all see that big old no audio
Are
sign?
you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? So, Mr. Lavity, you're currently on supervision. It's 34 counts total. All right? Let me go through them real quick.
All right, there's somebody else's. So this was the one I was reading. It was about Raymond Beltran, and he was supposed to be the officer who was watching Melly in the jail, y'all. So I think that this goes to speak to maybe like the conditions in which he was in and what he was in there doing, what type of supervision, or monitoring he provided. I didn't get all the way through it though. What I'm gonna do is I'm gonna try to find somebody who can read this with me and we can bounce off of one another. So I can read one person, they can read the other person, so it won't be so boring. So it won't be so boring. Or I can read it and summarize it. Either way. Well, y'all know what? I got an idea. Just give your girl a minute. Give your girl a minute. I got an idea. Yeah, Morley is up and she is yelling. Yeah. It is hilarious. I got y'all though. I'm gonna download the deposition and throw it in Chat GPT and tell it to summarize it for us. That way, I don't even gotta read it all, but we can have all the details. So just give me a minute. I'm gonna do that. Just give your girl a minute, and I'm gonna do that. Oops. Ooh, look at this judge. Hold this paper up. Let me find out he one of them. One of them no nonsense judge. One of them ones. Okay, wait a minute. The state done filed another motion too. Hold on, yeah. We're gonna have to see what they done filed. Wait a minute. They filed this oh no, this is about the song. So y'all know that they want to introduce like 58 songs this trial. So on January 8th, 2024, the state filed a list of 58 songs performed by the defendant that may be produced at the trial. In the above style case, the defendant filed a motion to compel additional information, including title of song, the name of the writers and composers, name of the performers, the release date, the date written, date recorded, the date and registration of copyright, as well as the date registration with the BMI. They say, looky here. What you ain't gonna do is try to make it seem like these songs that may have been written a long time ago got something to do with this trial that we didn't have. Or these M's. It says none of the remaining items 2 through 8 are within the state's possession, with the limited exception as noted for item number 3. The state is well aware of its ongoing discovery obligations pursuant to the case or whatever, or the statute, and has provided the information it is legally obligated to do. All right, just start going through some case law, discovery rules, all that good jazz. I'm gonna skip through that. The information the defendant seeks is information about his own songs that he has performed, his own licenses, and his own contracts. The information he seeks is more readily available to him than it is to the state. What the defense seeks to do here is to have the state do their, hold on, work for them. No good cause has been shown as to why this information is not accessible to them, or why the state can be compelled to produce something that is not under their physical possession or control. So basically, the state told the defense, hey, look, y'all need to give us all this information about these songs. And the defense is like, yeah, the information is easily available to us, but y'all got to do your own job and get that information. We're not going to do it for you. So baby, I can't wait to see how they argue this out here in court. Can't wait to hear them argue that. But that was filed a couple days ago. All right, now back to what I was doing. Trying to find that. I'm trying to find that deposition. Okay, yeah, I don't think I can buy a certified copy of it. Such a bummer. All right, so I'm gonna read through that deposition so we can know what's what with that movie. Exactly, Jen. I'm still looking through motions, y'all. See if there's something short that we could go over. That has been filed recently, though. Mm-mm-mm. Okay, Jen, it sounds like they didn't say, yeah, I got 58. It's 58 songs out there. We want all of the songs. We want the names of the songs. And we want to know who wrote them, who published them, all this stuff. So I agree with you. It don't sound like they know what's going on with them. They just said we're gonna find some music and some lyrics and we're gonna make it fit our case. I gotta run upstairs real quick, y'all. So I'm gonna be right back.
We're ready. Thank you. Ready for your guest. Stay here.
Yes, sir.
Okay, let me go back on the record. This is on the FT doc on the top of page 4. States versus Dennis. I've got Ms. Buckaloo, Ms. Collins, Mr. Griffith, present for the state. I've got Mr. Yancey, Mr. Aaron, present for Dennis, who likewise is present. Mr. Aaronson, you're telling me we're going forward without Ms. Liberty, without Mr. Benjamin, and without Mr. Today, is that correct? Yes. So, in preparation for the 2 days of all pending motions, I was going to put on the record, I know that the defense wants me to take one of these out of order. I think they're probably correct about that. But let me just put on the record real quick, everything that I've read in preparation for the all pending motions that I gave you all day today and all day tomorrow for. I endeavored to try to read everything in the electronic file, all filings and any authority cited therein that took place since this trial was declared in Mr. Rubin's previous suit trial, which was July 22nd, 2023. So these are all the pleadings that I read that were filed by the defense. I did read also all the orders that Judge Murphy entered, but I do realize some of these may be due, but in the abundance of caution, so I will be prepared. I nevertheless did read all of them. As we go through them, I'm sure you all will let me know if it's something that I need to resolve or it's something that's already been resolved. The defense, and I'll do these in chronological. I read the defense motion to compel Brady material that was electronically filed August 23rd, 2023. I read the defense motion to compel discovery that was electronically filed August 31st, 2023. I read the defense motion for discovery of prosecutorial investigations and prospective jurors electronically filed September 6, 2023. Defense motion for disclosure of penalty phase evidence electronically filed September 13th, 2023. The defense's motion in limine regarding phone, social media, and business records electronically filed September 21st, 2023. Defendant Jamel Deming's motion in limine to exclude certain testimony of Detective Mark Moretti regarding Apple Health phenomena electronically filed October 4th, 2023. Defense motion to exclude testimony of defendant's alleged gang affiliation electronically filed October 4th, 2023. Defendant Jamel Deming's response to state's motion to quash subpoenas and/or for protective order, and for an order to compel witnesses to be deposed and to attend hearing, electronically filed October 4th, 2023. Defendant Jamel Deming's motion to compel discovery, electronically filed October 4th, 2023. Defendant Jamel Deming's motion in limine to exclude certain testimony of Detective Mark Ray along with cell hawk, call, data, record, mapping, Google Maps, electronically filed October 5th, 2023. Defendant Jamel Deming's motion in limine to exclude certain testimony of Detective Mark Moretti regarding Apple Health phenomena, electronically filed October 5th, 2023. Motion to exclude testimony of expert witness and memorandum of law, electronically filed October 6, 2023. Response to state's motion to quash a memorandum of law, electronically filed October 9th, 2023. Memorandum Ray, ASA, Christine Bradley testified, electronically filed October 9th, 2023. Defendant's second motion for redeposition of Detective Mark Moretti, electronically filed October 29th, 2023. Defendant's second motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights.
Judge, that can be struck because we filed the third one and that incorporated the second. And we already have a ruling on the third one.
Okay, well, hold on. Let me get all of them,
All right.
and then we'll go one at a time. That's why I gave you 2 days. This one is defendant's second motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights. That one was filed November 1st, 2023. Defendant Jamel Deming's motion to exclude, electronically filed November 2nd, 2023. Defendant Jamel Deming's motion to strike the state of Florida supplemental discovery, electronically filed December 14th, 2023. Defendant Jamel Demons replied to the state of Florida's response to defendant's motion to strike the state of Florida's supplemental discovery list, electronically filed December 17th, 2023. Objection to business record certification and/or motion in limine, electronically filed December 18th, 2023. Defendant's third motion to compel forensic images of the cell phones belonging to Christopher Thomas and Anthony Williams, electronically filed April 15th, 2022. Defendant's request for status hearing, electronically filed April 15th, 2024. Defendant's motion to set aside stay and/or modify stay to allow discovery to proceed, electronically filed April 25th, 2024. Motion to compel discovery, electronically filed May 13th, 2024. Defendant Jamel Demons' motion in limine number 2 to exclude irrelevant and immaterial YouTube videos of 1090J, electronically filed May 14th, 2024. Defendant's motion to strike the state of Florida's motion for rehearing dated May 14th, 2024. That is electronically filed May 14th. And then a defense motion for hearing to determine potential conflict, electronically filed December 27th, 2020. From the state attorney's office, I read the following. State's motion to refer to potential and seated jurors by number instead of name, electronically filed October 6, 2023. State's motion to allow former testimony of state witness, filed October 6, 2023. State's motion to strike State Attorney Harold Pryor, Assistant State Attorney Regina Falk, and Assistant State Attorney Christopher Kilram from Defendant Devin's supplemental witness list for trial, filed on September 29, 2023. This pleading was electronically filed October 10, 2023. State's motion to strike Assistant State Attorney Christine Bradley from Defendant Devin's supplemental witness list for trial, filed on September 29, 2023. That's electronically filed October 10, 2023. State's motion for admissibility of consciousness of guilt evidence and a request for ruling prior to jury being sworn, filed October 20th, 2023. State's motion to withdraw State's motion to strike ASA Christine Bradley from Defendant Devin's supplemental witness list for trial, filed on September 29th, 2023. That is electronically filed on October 25th. State's motion to withdraw State's motion to strike ASA Christopher Killoran, ASA Regina Falk, and State Attorney Harold Pryor from Defendant Devin's supplemental witness list for trial, filed on September 29th, 2023. That is electronically filed October 25th. State's motion to withdraw State's motion to strike ASA Christopher Killoran, ASA Regina Falk, and State Attorney Harold Pryor from Defendant Devin's supplemental witness list for trial, filed on September 23rd, 2023. This is not a duplicate, this is an additional document, also filed on October 25th, 2023. State's Board Memorandum of Law, electronically filed October 30th, 2023. State's response to defendant's motion to redepose Detective Mark Moretti, electronically filed October 30th, 2023. State's motion to strike all jurors for cause with significant knowledge of the previous trial, electronically filed October 30th, 2023. State's motion for protective order and quash subpoena, electronically filed October 31st, 2023. State's motion limiting to prohibit defendant from improperly pre-trial his cause or making misstatements of law during board action, electronically filed November 1st, 2023. State's response to defendant Jamel Demons' motion to exclude, electronically filed November 6, 2023. State's response to defendant's motion eliminating Ray phone, social media, and business records, electronically filed November 6, 2023. State's response to defendant's motion to exclude testimony of defendant's alleged gang affiliations, electronically filed November 6, 2023. State's omnibus memorandum of law in opposition to defendant's motion to suppress evidence, electronically filed November 6, 2023. State's memorandum of law raised striking jury panel due to defense misstatement of the law, electronically filed November the 8th, 2023. State's motion to strike the defendant's second motion to dismiss for government prosecutorial misconduct in violation of the defendant's due process rights, electronically filed November 28th, 2023. State's motion to strike the defendant's unilateral setting of depositions and the the state's proposed deposition and motion schedule, electronically filed December 16th, 2023. State's response to defendant's motion to strike the state of Florida's supplemental discovery, electronically filed December 16th, 2023. State's motion in limine to exclude testimony of Michelle Boutros and Christine Brett, electronically filed December 17th, 2023. State's motion to strike the defendant's sworn motion to dismiss, electronically filed January 12th, 2024. State's response to defendant's objection to business record certification and or motion in limine, electronically filed January 23rd, 2024. State's motion to strike the defendant's request for status hearing and permission to proceed with litigation, electronically filed April 15th, 2024. State's motion to strike the defendant's request for status hearing and permission to proceed with litigation, electronically filed April 17th, 2024. State's response to defendant's motion titled Third Motion to Compel Forensic Images of the Cell Phone, electronically filed May 20th. I did also today do the state's motion to strike defendant's notice of hearing, electronically filed January 2nd, 2025, as well as the state's response to defendant's motion to compel discovery, filed on May 13th, 2024, electronically filed January 2nd, 2025. As far as previous orders that Judge Murphy entered, I read all of the following. Order denying defendant's motion for redeposition of Detective Mark Moretti, entered August 7th, 2023. Order on motion to remove electronic monitor, entered August 25th, 2023. Order denying defendant's motion to set bond, entered September 22nd, 2023. Order denying defendant's motion to recuse State Attorney's Office of the 17th Judicial Circuit in and for Broward County, Florida, entered October 12th, 2023. Order granting defendant's motion to recuse 17th Judicial Circuit Assistant State Attorney Christine Bradley, entered October 12th, 2023. Order granting State Attorney's motion to quash subpoenas and or for protective orders, entered October 12th, 2023. Order denying defendant's motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights, entered October 20th, 2023. Order on state's motion for inquiry of all pre-qualified jurors and motion for relief, entered October 26, 2023. Order granting in part and denying in part defendant's second motion for redeposition of Detective Mark Moretti, entered November 7, 2023. Order denying defendant's motion to declare section 921.141 subsection 6 subsection N of the Florida statutes unconstitutional, entered November 14, 2023. Order on deposition of state witnesses, entered on November 15, 2023. Order granting the state's renewed motion to reset the trial commencement date, entered November 15, 2023. Order denying defendant's motion in limine re agreement between Demons and Williams as to sharing of any money, entered November 17, 2023. Order re second deposition of Detective Danny Polo, entered November 21st, 2023. Omnibus order on defendant's motion to suppress numbered 1 through 13, entered December the 20th, 2023. Order on the state's motion for rehearing / reconsideration, entered January 11th, 2024. Order on defendant's motion to dismiss for violation of due process and double jeopardy and or motion to recuse entire state attorney's office of the 17th Judicial Circuit, entered January 19th, 2024. Order on state's motion for clarification, entered January 24th, 2024. Order denying the state's motion for reconsideration, entered January 25th, 2024. Order granting defendant's motion in limine re promotional video, entered January 25th, 2024. Order denying defendant's motion to set aside stay and order granting defendant's motion to modify stay to allow discovery to proceed, entered May 2nd, 2024. Order denying defendant's motion to set aside stay and order granting defendant's motion to modify stay to allow discovery to proceed. That's a duplicate. Order denying the state's motion for rehearing and reconsideration of the court's order modifying the state to allow discovery to proceed, issued on May 2nd, 2024. And that's issued on July 16th, 2024, not pro tunc to May 16th, 2024. So that's everything that I looked at, as well as any authority cited therein, statutes, case law, or otherwise. You don't have to repeat yourselves, but you certainly can if you would like to. I have the balance of all day today. I take a lunch break between 12:30 and 1:45. I can likewise give you the entire day tomorrow. I won't limit either side to present whatever evidence, witnesses, or testimony they would like to present. Defense, I'm going to start with you. And I also did read Rutledge versus State, which is 157 3rd 830, regarding the defense motion for hearing to determine potential conflict. So whenever you're ready, you proceed.
Thank you, Your Honor. Rutledge and other cases, federal cases, because state court really hasn't delved into this area as much as the federal case law does, indicates that there are certain things we need to find out first of all. So I don't know if this is the hearing or you want to set a hearing, but the bottom line of it is that the first thing we need to know whether Miss Liberty is still under investigation. We were told before the hearing by the state, I have no reason to doubt their word, that she still is under investigation. So that raises for us a number of problems. It may look on the surface that the only thing is, does Miss Liberty need to get permission from Mr. Devins to stay on the case and for him to waive conflict, but it's much deeper than that. And the reason why it's much deeper than that is we don't know what the state has subpoenaed. We do not know what they have in their possession. We do not know, other than the Apple accounts, if they've subpoenaed other things. Therefore, we do not know whether communications that we have had with Miss Liberty have been intercepted, and therefore, we've been told that nobody else on the defense team is under investigation, but there are certainly confidential communications that we would have had with Miss Liberty. There are communications about trial strategy that we would have had with Miss Liberty that we do not know who is in possession of them, what is going on with them. Now, the case law seems to be pretty clear that during this type of process with an attorney who's on a case, that the state is bound to return innocent or innocuous or confidential communications to Miss Liberty. But she has not received any. In fact, she didn't know there were any that were to be received until the date that's mentioned in the motion. So where does that put us? As I said, we've been told that the defense team, other than Miss Liberty, is not under investigation. But we do know that there's an ongoing investigation. What we have now been working for nearly a year or over a year with the state being in possession of documents dealing with Miss Liberty. If in fact Miss Liberty has to get off the case because of the conflict that she would have, this is a year too late. We should have been informed of this a year ago. So the defense team and Miss Liberty, and therefore Mr. Demings, for a year are working on this case with the state knowing that there's the potential that Miss Liberty will be indicted or an information filed against her in the exact same case of tampering with evidence and with witnesses. And if that becomes the case, she obviously, whether there's a conflict or not that has been waived up until that time, I think the case law is pretty clear. At that time, if she has charges against us, she has to bail out. In fact, I believe, and I'm not sure because it's federal case law, but I'd like to read to the court this paragraph from the case of U.S. versus Shagan, 661 Fed Sup 1289, 2009. In contrast to McLean, where the defense counsel was under investigation for a crime unrelated to charges against the defendant, here, defense counsel would have been under investigation for crimes that threatened the integrity and fairness of the trial. Were the government to inform the court at the eve of trial or during the course of trial that the defense team was under investigation for witness tampering. Under the principles of the claim and as conceded by Cronin, the defense team would be forced to withdraw its representation of Dr. Shaden. In fact, David Marcus made the motion orally as soon as he heard about the investigation. Such a development would have deprived the defendant of a defense team that had been intimately familiar with his defense, causing him severe prejudice. And that's where we're traveling down right now. Even if we stay on the case right now, if charges are brought against Miss Liberty and they happen to fall before the end of Mr. Demon's trial, we may be forced to, under the law, to withdraw as an entire defense team. But a question still needs to be asked. Why did the state wait, not to tell us, because they never told us, we had to find it out through Apple, that there was an investigation? Because a year ago, we would have sat with Mr. Devins, and he may have said, you know what, I need a new defense team. And we would have been off the case. But for a year, basically, we've been on a case that maybe we should not have. There are things that we need to know. We need to know who reviewed the warrant, who signed the warrant for the state as far as authorizing. We need to know whether there was a tainting. If all this information was gathered and given to the state attorneys that are prosecuting this case right now, there are innocent, innocuous, and confidential communications that will be in the hands of the state that is improper. A tainting should have been set up that reviews the documents and makes sure only those that are specific to the search warrant are looked at by the trial team. Questions need to be asked. If in fact Ms. Liberty is under investigation, then why were the subpoenas sent out and why did that investigation begin now? And what I mean by that is there's a statute of limitations. The state was under no obligation to begin that investigation until Mr. Demons' case is over. Therefore, there is no perceived conflict. There is no conflict because we don't know that they're thinking about investigating Ms. Liberty. But instead, we were not put in that position to know that, and a year went by. If they had waited to the conclusion of Mr. Demons' case, as I said, then there is no conflict. So the only thing that I get from this is that there's the chance that within the next whatever year, or 10 months until the trial date, 9 months, whatever it is exactly, that Miss Liberty is in fact facing charges for them. And if that occurs, then A, she can't try the case. Not sure the rest of the defense team can try the case. And don't know, as a prejudice to Mr. Demons would be monumental that at this late stage you'd have to get a whole new defense team. So we need these questions answered. It's not just a simple, is there an ongoing investigation? We need to know the extent of it. We need to know the whys of when it was instituted and why wasn't it, why didn't the state, wait for this matter to be over? We need to know whether the state, if they're going to charge Ms. Liberty with this crime of tampering, do they intend to try her at the same time as Mr. Demons, or a separate trial? Obviously, at the same time, it even raises more of a conflict. We have a question, and that scares us. Miss Liberty has not been allowed to see Mr. Demons in person for the last, before I got on the case, for at least the last year and a half. When she goes to the jail, she must pick up the phone and use one of those phones to talk to Mr. Demons on the other side of the glass partition by phone. Have they been tapped? Have they been listened to? We need to know what communications, what has gone on. So it's not just as simple as, is there an open investigation? Now, as far as going forward on these other motions that you say, We can't go forward as a defense team on any of these motions until we talk to Mr. Demings and have him understand what's going on. And for him, first of all, to make the decision. Yes, I want to keep this defense team. Yes, I want to keep Miss Liberty. Or no, I need a new defense team. We can't do anything until that's decided. I will say that after doing the research that I did over the weekend and came up with a case I cited to the court, I think all members of our defense team need to call up the Florida bar and to see whether we're obligated, now that we know that she's under investigation, that we're obligated or not to withdraw from the case, regardless of Mr. Demings' position. So that's where we stand today. With all apologies to the court, though, I do not believe we can go forward with these motions. Mr. Demings has a lot of thinking to do. Hopefully, the court will give us a hearing where some of these questions are answered, and then he can make a logical and an informed decision. And by that time, we can find from the bar whether we have obligations regardless of his decisions.
Rutledge says, I have to find out if there's an investigation, and the state says there is. What is your authority for all those other things that you said you want to answer? Because I didn't find any authority. I don't even know how I would do that.
Well,
Do you have any authority? I understand you're saying, that's the judge, this is what we'd like. I read what Rutledge says, that's what I'm doing right now. But you want to know about investigations, you want to know about a judge who reviewed a warrant. How would you suggest I do that? And more importantly, do you have any authority that supports any of those requests you just made?
well, the authority that I have, Your Honor, is the Sixth Amendment to the United States Constitution, which requires and which allows my client to have competent counsel. And without being able to go into these things, and I also rely on the 14th Amendment due process, without being able to go into these things and have a hearing where all these things are ferreted out.
A hearing, that's what I'm asking. I don't want you to confuse some type of hearing defending this liberty. That's not really the issue. That's a yes or no question. Is she under investigation? And the answer is yes. So the only other question that Rutledge requires is that Mr. Demings has to decide, does he want to go forward with her, or does he want conflict-free counsel, which I think he's certainly entitled to. And if he wants to apply that to all of his lawyers, he may do that. But that's a discussion between you and your client. I can't intervene in that. You're asking me to do fact-finding on behalf of your client so your client can make an informed decision.
Well, right. I will file another motion for prosecutorial misconduct and ask for a hearing on that. Subpoena witnesses in. The state will move to quash the witnesses that I will be calling in, and we'll have hearings going down that path. But this is something, no offense to this court, but I do not know how this court says that's the only thing that matters to me. There's a whole laundry list that deal with not only conflict.
That's what I'm asking. Do you have any case law that tells me I have to do that? I'm happy to do that. You cited Rutledge, and I read Rutledge. Rutledge doesn't
I
say
have
any
no
of those
case law in
things.
front of me right now that says you have to do that. But I would think it would be the inherent authority of this court that you should do that. And there's certainly nothing that says you can't do that.
That's usually that podium that talks to me about my inherent authority, which I don't exercise. I'm happy to do whatever a statute, case law,
Well,
criminal procedure tells me to do. I don't make up things on my own.
then I ask the court, let's go one step at a time. Right now, Mr. Demings now has been informed that Ms. Liberty is under investigation. And let us see what he decides. If he doesn't want us on the case anymore because of this, then all the things I've raised will be raised by another set of counsel. But if he does, we will be filing other motions in order so that we can get these questions answered, because Mr. Demings needs to know these before, quite candidly, he can make that choice. He can say right now that he wants Ms. Liberty, but after these facts come out, depending on what those facts are, he may decide he doesn't want Ms. Liberty or the rest of the defense team. So we'll take it one step at a time.
So your request is you want me to hear any of these today?
I don't think we can.
When would you like me to reset them?
I do not know how long it will take. Miss Liberty is not in town yet right now. She's on a plane. She got snowed in Montana yesterday. Drove from Montana to Seattle. She was on an airplane ready to come here, and they canceled the flight while she was on the tarmac. She got another flight including Phoenix. She's now on a plane from Phoenix to here. Almost all these motions that you went through are Miss Liberty's motions. So A, for logistical purposes, we can't hear those motions this morning at least. We're hoping that she's back at 1:30. But I do think it takes some time for us to talk to Mr. Demmons. She certainly needs to talk to Mr. Demmons. So, you know, you want to reset it for, I don't know if we can speak to him tonight sufficiently or not. You want to put it on for possible motions tomorrow and status tomorrow? You can, but I'm not sure that's enough time to talk to him.
It's not enough time when you can't do it. And we need to know, if I may.
Yes, sir.
We need to file, based upon your Honor's comments, we need to file a motion requesting certain things about this investigation. Concerning the tainting, whether or not they relayed any of that information to the prosecutors or the investigators in this case. And I want the court to know, they didn't tell us. Apple informed Miss Liberty that a search warrant was issued on her Apple account back on December 13th, 2023. As a result of that, I contacted the Broward Sheriff's Office and spoke to Christian Sabanas. And I sent them a text message that said, I was just advised that Broward Sheriff's Office issued a search warrant on Miss Liberty's Apple account on December 13th, 2023, over 1 year ago. I would like to discuss this with you. He responded by saying, hi, Stu, I have zero knowledge of this search warrant or its application. Your email is the first I have heard of this. I would defer to whoever the affiant was. I don't have access to that information. I in turn contacted the state, and they said they would get back to me, which I spoke for the first time this morning to the state concerning this. I think we need to know the procedure of the so-called pink team so that any privileged communications were not relayed to the prosecution team and or its investigators. We also need to know why, since Miss Liberty represents numerous other clients, whether or not they have severed or separated those privileged communications that have nothing to do with their so-called investigation. We need to find this out.
Well, do you even know the investigation has to do with this representation? That's exactly what I was just thinking, what you just said.
I assume it is, since it's issued from the Broward Sheriff's Office.
How do you know it isn't related to one of our other clients or one of our other cases?
Well,
Has
that's all I
anyone
have.
said anything that this has anything to do with Mr. Demmons?
I can't answer that without seeing the search warrant.
We're not here to make work. Does this have to do with Mr. Demmons?
It doesn't.
Okay.
So can you give them a copy of the search warrant?
No, because it's a pending investigation that's still ongoing.
How does Mr. Demmons make a decision about whether he wants to waive any potential conflict or not without having that information?
The only thing I can say, Your Honor, is again, it's a pending investigation. Knowing that she's under investigation is what Rutledge talked about. We can't give anything over until it's officially completed.
With all due respect, but this is the high due process part when the state's seeking the death penalty. The state's seeking the death penalty. So you need to turn over the affidavit and the search warrant so the lawyers can make an informed decision. All right.
It does not have to do with the homicide case.
Well, in any case, he needs to know if there is a potential conflict of interest. He's either going to make an informed, intelligent waiver of that, or she will no longer be his lawyer. And then he has to make the same decision for all of his other lawyers. And he is going to trial September the 10th, 2025. So we need to do this now. So how long will it take for you to get a copy of the affidavit and a copy of the search warrant and give it to opposing counsel?
I'll have to speak with my office and you can have a week to figure this out.
Judge, they've had since December of 23. They didn't even have the courtesy to inform us of a pending investigation. We had to learn this from Apple.
you're telling me it relates to this case.
To the tampering case.
So why would this be different than any other search warrant in any other criminal case? Defense counsel would be entitled to it.
Because she's not a subject that's been charged yet, potentially could be. It's pending investigation. All I can say is, again, pending investigation, there is a team in place, and it's still pending. So it's not like we have to hand over discovery to her. She's not a listed defendant yet.
No, but let me repeat myself. Mr. Devens has to make an informed decision about who he wants his lawyers to be. He's now been sitting in our jail for 2,159 days. So how long would you like to be able to make that decision?
I can't determine when the investigation will be over. That's up to the Broward Sheriff's Office, but I can, as I said, I'm just asking for a week to determine whether or not we need to file any sort of motion to prevent the search warrant from being over.
I just can't imagine any legal ground for that would not happen in this particular case. It's a death penalty.
I understand
It's a
that.
death penalty.
And then I'm asking for at least a day or two. At
You can
minimum.
decide by tomorrow. I've also reserved all of tomorrow. I took over Division FT. Judge Murphy had 44 pending first-degree murder cases. I've set them all for trial. I'm booked to trial through July of 2026. So if you all think I have 2 entire days at some point in the next 18 months to do these again, I do not. So
Understood.
I'm not sure what it is you want me to do. You don't want me to do anything else today.
We can't under the Florida rules.
So do you want me to leave them on for tomorrow? You will have the balance of today to discuss all these issues with Mr. Devens. And state you will have the balance of today to discuss some reason why you can't just turn over this affidavit and search warrant.
That's
I
fine.
mean, it may be something innocuous. By the way, for the record, I don't know anything about this. No one brought me a search warrant, so. But maybe it's something so de minimis that Mr. Devens is going to say that's fine. If there's any conflict, I'll waive it, and let's get to work. Or if not, I guess he's going to have to go find 5 other lawyers to do this who are going to be ready to try a capital case in 9 months. So how about tomorrow at 9:30?
We'll be here.
Stay tomorrow at 9:30?
That's fine, Judge.
And it can't, again, I'm not picking on you, but the answer can't be, my office told me X, Y, Z. Someone better be standing here with some authority that tells me they can't do it. Okay?
Judge, one other thing.
Yes, sir.
You mentioned about the trial schedule, and we're obviously going to try to do it. I just want to let you know, the matters that were appealed are still up in front of the 4th DCA. The state, I believe, just filed the last document in the case, or there may be one more that they need to file, one more reply brief. I would suspect that it's going to be set down for oral argument, and then I don't know when we will get a ruling. The problem is the stay that was issued by your previous judge. We cannot go into anything on any type of discovery as far as depositions, as far as motions, as far as anything dealing with the matters that are up on appeal. So when that all comes back, we will be rushed to get everything else done. Just want to let the court know, we're under the mercy of the 4th.
Is there anything pending at the 4th DCA regarding the tampering?
Yes, everything that was on the homicide is also on appeal for the tampering because it's the same evidence.
Yep.
And Judge Murphy entered an order.
Entered an order that says you can't do depositions.
We can do depositions on things that aren't on appeal. So we have been doing depositions on things that aren't on appeal.
For example, you did not read, unless I missed it, but there is a motion in which I'm asking the court to make the state tell us what of the 2 million or whatever amount of Instagram messages they intend to use at trial. That was filed a long time ago. We can't have that hearing because the Instagram messages, the whole thing is up on appeal. So we can't even go into that motion. Those are some of the things that await you.
Well, can I give you rulings on all those, depending on what, if I rule some messages are in and some messages are out, for example, and the 4th DCA says they're all out, then they're all out.
Judge, I wanted to move this case. I'm just.
Do you have any objection to doing that?
We're not the ones that filed this day.
Do you all have an objection to doing that?
Well, I think I'm confused on the motion that you're bringing up because all of the Instagram, if I remember correctly, I have to look. is up on appeal.
Right.
So, I mean, it would kind of a waste of time to do the motion.
No, a waste of time is reserving 2 entire court days and doing nothing. That's a waste of time. So do you have any objection to going forward and the hearing and ruling on any and everything that's pending?
I think that we should start with the things that don't affect the appeal, and then, because there's plenty of those to be heard, and then we can go forward potentially with the other ones.
And I'll be candid, I do not think we were hearing the Instagram matter whatsoever. So I'm not looking at that motion.
Okay, so why don't we do it this way, all right? He's gonna remain on the docket tomorrow. I have a few other matters on both FX and FT, so let's call it 9:30 tomorrow. And, defense, you can come in and tell me if you had a chance to talk to your client, because if he's gonna waive any potential conflict, I guess it doesn't matter.
Yes, it does, Your Honor, because he'd be waiving a conflict without knowing what's in the search warrant affidavit.
Correct.
So therefore it would be an invalid waiver because he's not totally informed of the facts.
Okay, you're gonna tell me what you wanna do, state, maybe you can identify the motions that you think we can go forward. I mean,
We sort of addressed it in the motion to strike the notice, because we've been asking since our hearing in October to know what motions are going forward the next 2 days. Couldn't get an answer. We've asked in depositions from Ms. Liberty, couldn't get an answer. We emailed, we couldn't get an answer. And then just a few days ago, we got a notice of hearing. Half those motions aren't even filed within the court file in honesty. So we identified, I think, 4 that we are ready to go on, that we filed responses on. There's no motion filed for somebody's.
you're gonna go to trial in September. All right. I'm not prejudging things.
I hope so, Judge.
No, I can absolutely guarantee you, he's gonna go to trial in September. So I'm gonna do everything that I can. If I have to rule on things during trial, which is an awful way to do things, because I know you both know, but if that's what it comes to, then that's what we're gonna do. So,
Assuming we're still on the case. And that's a big assumption at this moment.
And just, they're still asking for proper notice of what we're actually
I'll take the blame for that. All pending motions. That's why I put that down for hearing tomorrow. All pending motions. They're asking for I believe they're asking for a Galbert hearing on cell phone records. They're asking for a Galbert hearing on some other matter, cell phone mapping. There's a whole bunch of things that.
Some of those have already been ruled on, Your Honor. The ones that they've noticed, I think, and again, Ms. Liberty admitted to this the last time we were here in front of Your Honor, that she filed things with the wrong case number, wrong title. She's going to fix that. None of it has been fixed. So the state is entitled to proper notice so that we can respond accordingly.
We'll see you tomorrow morning. Fair enough?
Okay, I'll see you at 9:30 tomorrow. Ms. Wilcox, does that otherwise conclude FX and FT for today?
Yeah.
Okay, so the FX and FT are both going to otherwise be in recess until tomorrow, which is?
Excuse me.
Yes, sir.
I've been told that Mr. Devens has federal court tomorrow morning on his civil hearing. Does corrections have any idea of that?
Not tomorrow, sir.
Huh?
It's not tomorrow.
It's not tomorrow?
I believe it's January 17th.
17th. Forget what I just said. Thank you. We don't represent him on that.
Tomorrow is Tuesday, January the 7th. FX and FT, we're going to recess until then at 8:45 a.m. I would be able to be good for the rest of the morning. All right, Mr. Court Reporter, that is it.
Oh, okay, 10 minutes.
Here.
No, the jail.
Thank you.
All right now, y'all. We thought that we was gonna get a show,
Have a
and
good
we
one.
did. We
Use your
absolutely
timeline.
got one.
Yes,
So,
sir.
but when we first started the stream, y'all, I went through the motion where they the defense basically calls out what was argued. Miss Liberty is under investigation. If you don't know who Miss Liberty is, she is the female attorney that is representing Melly. Okay. Basically in December, I want to say December the 18th, Miss Liberty was notified by Apple that her account had been subpoenaed by Broward County's sheriff's office. And so basically they went and they found out that she was under investigation, but they had subpoenaed her Apple records a year prior. So back in December of 2023, the prosecuting team, the state did not tell the defense. They didn't tell them at all. They told them nothing. And the defense attorneys just basically came in and raised their concerns. They said, look, Judge, we are not comfortable arguing any of these motions that we have on the calendar today. Why? Because Miss Liberty is under investigation and we need to understand what, why, who, when, where, what is really going on, because the state has not told us anything. They refused to move forward. Plus, the motions that they were getting ready to argue were motions that were for Miss Liberty. Now, where is Miss Liberty? She is stuck in Montana somewhere because it is a snowstorm. We were talking about it a little bit earlier today. We all snowed in. All right, everybody is trapped from the snowstorm, and she couldn't make it to court. So they want to know, and we found out during this motion hearing that she's under investigation, not due to her other clients, but due to Melly. And the defense is concerned that they have access to attorney-client privileged information. They are concerned about whether or not Melly wants to continue on with his legal team or not. And so, to make a long story short, the judge ruled that. Well, the judge actually just flat out asked the state, is Miss Liberty under investigation for Mr. Demons? They said yes, it is still active. And they asked her to turn over the affidavit and the search warrant. And she said no. She said, look, I don't want to give that to you. And he told her, look, Mr. Demons is going to trial. I don't know if you know, but I inherited a whole lot of cases. All right. And I didn't set all of them up for trial. And if you think that I got other days to wait on you, baby girl, I don't. I don't got the time. So what you need to do, tomorrow morning, we're going to come back at 9:30 a.m. I need you to come back. I need you to show up, and I need you to turn that information over there to them, because regardless if it has to do with this murder investigation, it has to do with whatever tampering or whatever case that you got going on. And he needs to make a decision. He's going to trial. And so you need to figure it out. He told her, look, unless you tomorrow, don't come in here saying that somebody from my office said. He said, you better have somebody in here with some authority to tell me why you can't turn that information over, because he been in jail for 200 plus days. I'm sorry, 2,000 plus days. All right. So tomorrow we will be back at 9:30, which will be 8:30 Central, to see what happens, because we need to know what's getting ready to happen, y'all. I am so intrigued because what? This was not on my bingo card. This was not on the bingo card for today. Like, what the hell? Y'all mean to tell me y'all just subpoenaed this lady? Y'all done got this lady under investigation. Y'all got her entire Apple account. Ain't no telling what she was talking to, who she was talking to, and what she was talking about. But that was crazy right there, y'all. Let me know what y'all think in the comments. All right, y'all. So I'm going to go ahead and wrap us up today, because like I told y'all, we got a snow day. So I got to get back upstairs to them babies. But child, they said that they got a search warrant on Miss Liberty. What is going on? All right, Taylor gang. See y'all later. Y'all have a good day. If you have a snowstorm in your area, just make sure you stay safe. See y'all later.